Afternoon. We're back to the June session of the Court of Criminal Appeals. The panel today, to my left is Judge Robert Montgomery from Kingsport. To my right is Judge Kelly Thomas from Maryville, and I am Norma McGee Ogle from Sevierville. 20 minutes per side. And if you would like any rebuttal time, please let me know before you begin. You're welcome to stand or sit, whichever you're more comfortable doing. And you can argue with or without your mask, so long as we can hear you. And with that, I think we are ready. State of Tennessee versus Breeden.
Good afternoon, Your Honors. I'm not going to stand. I mean no disrespect, but I think I can't read my notes or see them even if I'm standing up. So if it pleases the court.
That's no problem.
I'm Patrick Frogue. I'm the director of the Public Defenders Conference. I'm here on behalf of Ricky Breeden. I would ask for 5 minutes in rebuttal. Your Honors, if I may, I'd really like to focus. There are 4 issues raised in my brief. I'd like to focus on the first 2. Of course, I think all 4 have merit, but issues 3 and 4 are sufficiency and sentencing. I think they're adequately briefed by both sides. I don't think I would add a lot with oral argument. It's issues 1 and 2 that I think oral argument I can illuminate a little bit more. So I'd like to focus there, if I may. Of course, I'll answer any questions you have on any of the issues. Your Honor, the first issue is the court's refusal to allow Mr. Breeden, an expert, to testify at trial. This hits particularly close to home as I'm the director of the Public Defenders Conference, because the reason this is an issue is primarily because Mr. Breeden's indigent. If he were not indigent, he would have certainly hired his own expert. I think a brief review of the transcript would show you why. And if I may, I don't want to go through all the facts in this case. I think a quick timeline about the ex parte motions and how we came to be here might help. On February 5th, this case was indicted in 2017. On February 5th of 2018, Mr. Breeden moved ex parte for funds for an investigator. 4 days later, the court set the case for trial in February, announced there would be no negotiated settlement, and apparently, although not in the order, set a discovery deadline 2 months later in April. 2 weeks after that, the court denied the motion for the investigator. We're not to the medical expert yet, and noted in the order that counsel had not sought funding from the Tennessee District Public Defenders Conference. So that was denied. I'm not raising the investigator motion here. We were able to investigate, but that's how we started. April 6th, the discovery deadline came and went. The state apparently, there's no record of this, but the parties reference it in their pleadings. Not these parties, but the parties at trial reference in their pleadings. The state moved for a week to continue. They were still gathering discovery. April 10th and 11th, the state issued its final round of discovery. Apparently there had been some preliminary discovery, and in it was voluminous medical records, 7 medical witnesses. This is 2 months before trial, around April 10th or 11th. In response to that, the defense, according to their pleadings, reviewed those filings as best they could, and then decided they needed an expert to consult with. They went and got funding from the trial court. The trial court did find that they had met the standard and agreed to a limited amount of funding. The order limited it to 15 hours to review at $90 an hour.
So that was a very specific request.
It was, that's right, and a specific order. Now, here's where I think the record does make this clear once you read through all the hearings. Apparently there was a practice, I'm unaware of it being from Middle Tennessee, of relying on someone named Dr. Pettigo. And Dr. Pettigo, I guess the record makes it pretty clear to me, is, for lack of a better word, was a former medical examiner who was somewhat disgraced, and I mean no disrespect to anybody, but apparently the reason the court said that they allow it and the defense said they rely on it is because he was cheap and available. After about 3.5 weeks of reviewing those records, he sent an email to the defense that said, hey, we're going to have to get a better expert. You're going to have somebody testify at trial. That was May 7th when they got funding for him. On June 6th, he sent the email. The trial was set June 25th. And on the same day, the defense moved for, we've got to have a testifying expert. What we're afraid of, the state had talked about bringing a witness in to say, these allegations are as serious as a heart attack. It's a 5-year, somewhat violent sexual relationship that this guy had, the defendant had with a little kid. And the medical experts for the state are saying there's no evidence of trauma at all. Given the allegations, Dr. Pedigo said, I think there ought to be. I think you need somebody to say that in trial. So on June 6th, the defense filed a motion to continue, not for further funding. The trial was set in 2 weeks, and the defense said, we need to continue this. We need to get a testifying expert. That continuance was litigated. The state was there. They talked openly about the medical proof. They talked openly about the need for an expert. The court denied the continuance and said, you know what, you bring me back an ex parte motion. I'm not saying you haven't met the standard yet. Maybe you will. The defense had to shop around for an expert that would do it. And on June 19th, 6 days before trial, they filed an ex parte motion seeking funding. They found an expert. The expert said that she wouldn't do it for the state rates. And so the public defender said, I'll pay the extra out of my local budget. We don't have a budget line item at the public defenders for that. That comes from the Supreme Court's Indigent Defense Fund. But given the timing and whatnot, I'll pay any overage. And the court said no. The court, there was a lengthy ex parte hearing. The court said, I'm skeptical of any expert that didn't treat the victim in this case, whether it's called by the state or you. Do you expect that the state's going to call an expert? The defense said, I think that they will. They've mentioned someone who they've called in previous cases. She's sort of known to testify there are no injuries in these cases. And the court said, I've got reservations about any expert that hasn't treated the victim. Trial 6 days later, they did call an expert, but not one who hadn't treated the victim. They instead called the treating physician, qualified her as a pediatric expert, and she testified substantially to what the defense feared.
Was this Dr. Westmoreland?
Yes. And she testified, there don't necessarily have to be injuries despite allegations of penetration with a little kid over 5 years. Doesn't matter. It's not going to hurt. It's not inconsistent with the allegations. The defense attempted to cross-examine the witness, but I think you'll read in the transcript, was ineffective. Not constitutionally ineffective in my opinion, but they just didn't have a lot to work with. So what you have at the end of the day is the state had access to 7 medical witnesses, a medical expert, the only neutral party that the trial court saw that was in the trial, and the defense had an expert who was a convicted felon, apparently, who was unqualified to testify. And so the defense was there with no expert testimony. I think it's pretty clear when you look at the allegations. I mean, in this case, the evidence against Mr. Breeden was 1, the victim's allegations, and 2, the defendant's statement. The defendant's statement was hotly litigated. The officer who took the statement said, I only wrote down the parts where he admitted. He did make several denials, but I didn't write those down. That's the evidence against Mr. Breeden. And I think the verdict reflects it. This was a 14-count indictment. Of those 14 counts, the jury found the first 3 counts that were based entirely on the victim's testimony not guilty. 2 of the counts were nollied at the beginning of trial. 4 were JOA'd at the close of the state's proof. So we're left with 5 convictions. So if the court gets to a harmless error analysis, I would say this was not a slam dunk case. Out of 14 counts, 5 were guilty. 9 were dismissed or not guilty in some capacity, including counts where the victim clearly testified as to what happened. So I think it's pretty clear the defense met the standard. I also think it's a stretch to say it's harmless error in a case with this kind of verdict. I'm happy to answer any questions at any time, but I will move on to my second argument,
proofs in the record that you say establishes particularized need?
Yes, Your Honor. Well,
Who
so
was the expert that hired?
I can't, it's a hyphenated name that I simply
Oh,
can't
Dr.
pronounce.
Malusnik. Oh,
You pronounced it perfectly. I've only read it and didn't
well, I've
have a
heard it
chance.
100 times,
Yeah,
Knox County Medical
in
Examiner.
person and read it.
I'm not sufficiently, I don't spend sufficient time in East Tennessee to know all the characters, but that's right. That's the expert.
Okay, all right, thank you.
And the particularized need, let me just say, since you asked, the particularized need necessarily, because they hadn't hired the expert yet, was the defendant's lawyer saying, here's what the expert told me, and here's what the other expert told me the expert would tell me. So it was a proffer, essentially. It wasn't actually a sworn affidavit by the expert. It was instead a summary of what I think the expert would say and why I need it. The second issue I'd like to focus on is the failure of the court to elect offenses at all. We all know, I mean, you all have done this a long time. These cases are difficult to prosecute. They often involve, like this one, child's testimony, vague memories, long periods of time, allegations of abuse that spanned multiple years. So we give the state a lot of leeway. They're typically tried together as a single course of conduct. Prior bad acts come in, lots of leeway. But the one safeguard, the one reason we allow the state this much leeway is because there's an election requirement. Okay. Here, the court could have done this multiple ways. One, they could have simply elected in front of the jury. There was a bill of particulars motion filed by the defense. The state answered it more than a year before trial. The parties were on some kind of notice as to sort of roughly what counts equated with what testimony by the victim. The court did not force an election. The state didn't either. The second thing that they could have done is simply instructed the jury very specifically. In the absence of saying election is important, we're going to elect, the court could have said, all right, here are these very specific jury instructions. That would, I think, have been harder for me to survive a harmless error analysis or the plain error holding, but they didn't. They issued jury instructions that equated with the state's original answer to the bill of particulars, but it's not specific enough. In fact, there are several counts of child rape that aren't very distinct from each other, and the 2 counts of ag sex battery that at least are on the same time frame. So the third thing they could have done is the state could have closed clearly. The state could have at least partially cured this error. I think the state notes in its brief that it's not a substitute for election, but it fits into the harmless error analysis if the state clearly closes. And there is a disagreement between the parties about how clear that is in the record. I think you're just going to have to look at it rather than take our word for it. But I don't think it's clear at all.
You mean as to whether they did the closing arguments before the instructions?
No, as to whether the closing arguments actually specifically outline which behavior goes with which count. They made a stab at it. The state made a stab at that. They did. It appears to me, reading the record, that what they did, they intended to, but then they kind of got off the rails in closing, which happens sometimes, and they ultimately didn't really narrow it down. So here we have a case where there was no election. I mean, that's clear. I called it an ad hoc election in my brief. The jury instructions existed such that they were, but they weren't that specific, and closing argument didn't really do much to cure it, in my opinion. You'll have to look and see if you agree. So I think it's, from my perspective, I think it's pretty clear that we made the standard. I don't think the parties disagree on the law. I think this is plain error. They did not raise it. The defense didn't raise it at trial. There's no indication why that would be tactical. There's no indication in the record that it was tactical. It's clearly a substantial right. It's a clear rule of law. And I think it was harmful in a case, again, that was close. These 5 counts that ultimately the defendant was convicted of were 3 ag rapes and 2 ag sex, rape of child, excuse me, and 2 ag sex batteries. Okay. The problem with these jury instructions, imagine if you're a juror, what you're hearing in the absence of election and all this is not only the way you and I might talk about it colloquially, you're also hearing lesser included offenses on these rape of child. So when you're trying to distinguish between all these charges, in the absence of a clear election, clear instructions from the court, or a clear closing argument, I mean, I would defy the court or anybody who reads this record to walk out of it and clearly know what the defendant ultimately, what survived JOA and what survived the knowledge to make it to the jury, and to distinguish those acts from another with a kid testifying.
Were there, and I could not determine this from reading the briefs, were there 3 separate counts on actions that took place as part of one event?
Well, I think when you say part of one event,
I'm trying
I think
to not
you're
get
saying-
too specific.
Right. I think it's part of a 2-week period. Ultimately, what the jury came back with, the 5 counts, were based on a 2-week period that were more recent to the discovery, you know. But no, I did not hear that there were 3 counts related to one act. But it was one 2-week period. I think all of the guilty counts were indicted for, ultimately the bill of particulars said, was a 2-week period within a few days of the disclosure by the victim. So in the absence of any questions, I think that those 2 issues, what I'm asking for, what Mr. Breeden's asking for, is a fair trial. He's asking for a trial where he can rebut expert testimony. He's asking for elections to be imposed. So we're asking for a new trial. I'm happy to answer any questions, or I have no idea how much time I just took. I'm sorry I didn't time it.
You have your rebuttal time left.
Thank you.
You have about 5 minutes left, actually.
Oh, perfect. Thanks.
May it please the court, Courtney Orr on behalf of the state. I'll first address the issue regarding the funding for the second expert witness in this case. The trial court properly exercised its discretion when it denied the defendant's motion, because the defendant did not show a particularized need for additional funding for a second expert. Dr. Molinsnik-Polchan, I also have problems pronouncing her name, I apologize. First, the defendant could not show, or he merely alleged a hope or belief that Dr. Molinsnik-Polchan would testify that failure to conduct an internal exam of this victim 10 days after the last alleged encounter with the defendant could have potentially uncovered exculpatory evidence. There's nothing here that would show that it would. It was just a mere supposition or hope, which this court has held is not enough to show a particularized need. And additionally, the medical information which the defendant sought to get in front of the jury were well within the capabilities of trial counsel, and he indeed did get this information to the jury without Dr. Molinsnik-Polchan's testimony. Through the assistance of Dr. Pedigo, the defense attorney learned that had the defendant and the victim engaged in 5 years of fully penetrative penile and vaginal intercourse, there may have been, or the doctor would expect to see some sort of stretching or damage to the hymen. During cross-examination, the defendant asked Dr. Westbrook about whether she would expect to see damage to the hymen if these were the facts that the state had alleged. And Dr. Hyman testified, yes, if these are the facts that were given in the victim's medical history, then I would expect to see this type of damage or this type of evidence within her exam. I did not note any damage to her hymen in my report, which indicates that I did not see any in her exam.
She gave very detailed testimony.
The victim?
No, Dr. Westmoreland,
Yes, she did.
which I started reading the briefs. I thought, well, you know, there's not much as far as the experts initially that are going to hurt this defendant. But then Dr. Westmoreland's testimony is very specific, particularly as to damage to the hymen and what she would expect to see. And it appeared to me that they would have benefited by their own expert to come back in and testify as to Because apparently there was a disagreement on that.
I would submit that Dr. Westbrook's testimony was so detailed because she did examine the victim. She was the treating physician in this case. But I would disagree that additional expert testimony would have gotten information to the jury that trial counsel was not able to do himself through cross-examination of Dr. Westbrook. Dr. Westbrook did testify that she would expect to see and would have noted damage to the hymen had the defendant engaged in 5 years of continuous, fully penetrative vaginal intercourse with this victim. And she did not note that, which indicated that she did not see that type of damage. Now,
Well, how was that dealt with?
excuse me?
Wasn't that the state's allegation in the indictment? It's been going on 5 years?
It's the state's alleged child rapes that went on for 5 years. However, the state's theory at trial was that the defendant did not achieve full penetration in any of these rapes. Its specific theory at trial was that the defendant had attempted to engage in full penetration, but had only slightly penetrated the victim's vagina because, as a child, the vaginal opening was too small. It argued that specifically to the jury. And based on the medical evidence and the medical testimony in this case, the hymen, which sits at the opening of the vaginal canal, either was not penetrated or was very slightly penetrated, and Dr. Westbrook testified that if there was shallow penetration, she would not expect to see this type of damage to the hymen. The
How did they dispute that without medical proof or an expert?
Well, the proposed expert testimony was not about shallow penetration. It was about fully penetrative vaginal intercourse. So we submit that even if this court were to find error and to go to a harmless error analysis, that because of the state's theory of shallow penetration in counts 5 and 10, it was harmless beyond a reasonable doubt because there was no allegation that the defendant penetrated the victim's vaginal canal, which would have damaged the hymen. And as to counts 7, 9, and 14, any additional medical expert testimony would have been wholly irrelevant because the medical expert testimony was solely related to what would be recovered in a vaginal exam in counts 7, 9, and 14, alleged fellatio and touching of the victim's breast. Turning to the election of the offenses, I just would like to clarify that this issue is before this court on a plain error review. It was not included in the defendant's motion for new trial, and so therefore the issue is waived. But consideration of this issue is not necessary to do substantial justice. I would agree with the defendant that the state did not make a separate election in front of the jury that identified the factual basis for each count, as is required by the laws of the state. However, the state very clearly identified the factual basis for each count and paired that factual basis to each count in its closing argument, which, while that does not cure the election error, does render it harmless beyond a reasonable doubt.
How does that impact our sufficiency analysis when you have this many separate counts?
I believe when your honors look at the record, you will see, especially with the rape of a child cases, the state in its closing arguments identified the factual basis for each count and said, this factual basis relates to counts 7, 9, or excuse me, 5, 7, and 10 are the rape of a child case. And I specifically identified those factual bases to the count number. And within those factual bases, they highlighted all of the distinguishing facts between these cases. 2 of the rape of a child cases were allegations of vaginal sex, in which the distinguishing factor was where the victim was laying on the defendant's bed, and the state specifically highlighted those distinguishing facts. The 3rd was an act of fellatio, which the state identified. As to the aggravated sexual battery charges, the state did not specifically name the numbers of the counts, but there were only 2 aggravated sexual battery charges that went back to the jury, and the state identified for each of those One of the aggravated sexual battery charges is when the defendant touched the victim's breast over her clothes, and the second is when they touched her under her breast, under her clothes. The jury had the information about the factual basis for each count, could identify the counts to which those factual bases applied, and could render a unanimous verdict in this case. So unless there are any further questions from this court, we will rest on our brief for the remaining issues, and we ask that you affirm the judgments of the trial court.
Thank you.
I certainly don't have 5 minutes. I guess the only thing I would add that I maybe missed in the first argument, and Ms. Orr reminded me, was the argument in her brief that it's harmless it's harmless error as to the sex battery counts because those didn't involve penetration, and what could an expert add to that? But fair enough, that's an interesting point. I will say, though, that if we had a medical expert that came to court and testified the way that we allege she would testify and the way I would expect an expert to testify, it would have cast doubt on all of the allegations by the victim. So, for example, I think a jury would be hard-pressed to say, oh, all right, the expert testified, the victim must have lied about the rapes, but we find that the ag sex batteries are there. So I think it's in the context of the whole trial. There was one neutral person who testified. It was the treating physician, and she testified. Her testimony was damning to the defendant. There was an expert available, ready to testify at state expense, and the public defender did something that I would have refused him doing had I fully comprehended it. Offered to pay out of his own budget, shorting other parts of his budget to make up the difference. That expert was available and would have contradicted that. So that's why I raised it. Thank you.
That concludes the argument, and we will take a 45-minute recess before we begin the last case on the docket.
Also, thanks for scheduling this during the COVID. We really appreciate. On behalf of both of us, we appreciate the schedule.
Well, the court thanks both of you and all of the court staff and the technology folks that came from Nashville to help us make this possible, and we really appreciate you.
Thank you.
You all both did very good jobs with quality.
Thank you, Your
Thank
Honor.
you.
All rise. This court is in recess until 4 o'clock today.
Thank you. What's your name?
I'm Jim.
Jennifer Patrick.
Patrick.